So, hello, I'm Dr. Tom Hannant. I'm a lecturer in public law from the Hillary Rodham Clinton School of Law at Swansea University.
And I'm Alex Latham-Gambi. I'm also a lecturer at the Hillary Rodham Clinton School of Law.
So we're here to record a discussion of a UK Supreme Court case from last autumn. It's called the Miller and Cherry case, and it involved those two people bringing a challenge against the Prime Minister's decision to prorogue Parliament. It's a case that was very high profile at the time, and with which I'm sure many of you will already have a kind of a basic level of familiarity. So I'll start by asking Alex a question about the case. Alex, can you tell us a little bit about the background to the case?
Yeah, sure. Well, this case is a case to do with Brexit, and I suppose the background really goes all the way back to the Brexit referendum in 2016. Now, after that referendum, obviously the vote was to leave the European Union, and the then Prime Minister David Cameron resigned. New Prime Minister Theresa May took her place, and shortly afterwards she invoked Article 50, which basically started the procedure of the UK leaving the European Union, and that's kick-started a 2-year period for negotiations to take place, after which the UK would leave the EU. Now, the original date that was set was the 29th of March 2019. That was 2 years after Article 50 was invoked. However, there were some problems that the government encountered in getting the withdrawal agreement, the agreement to enable the UK to leave the EU, to getting that passed through Parliament. Parliament voted against the withdrawal agreement on a number of times. And because of that, the withdrawal date was postponed, first of all, just for a few weeks to the 12th of April, and then from a longer period all the way up to the 31st of October of last year. Now, this was a very fraught period in Parliament, and Theresa May was failing to get the support of a lot of her own Conservative backbench MPs to vote for her deal. When it became clear that she wasn't going to be able to get that deal passed through, she stepped down as Prime Minister, she resigned, and Boris Johnson took over. Now, when Boris Johnson came in, he wanted to renegotiate a new withdrawal agreement. And he thought in order to do this, he needed to levy a threat against the EU, to threaten the EU that we would leave without a deal, and that we were serious in this idea of leaving without a deal unless they gave us an improved withdrawal agreement. Now, the difficulty with that was that Parliament were very much against the idea of us leaving without a deal. And the EU knew this. The EU knew that Parliament would do everything it could to stop us from leaving without a deal. And therefore, Boris Johnson wanted to try and get around Parliament, to try and prevent Parliament from stopping him from potentially leaving the EU without a deal.
Okay, so the process had become a logjam by this point, and of course, as everyone will remember, the political tension was running really high. So what did the Prime Minister do to try and get around Parliament?
Well, what the Prime Minister did was at the end of August, on 28th of August, he asked the Queen to prorogue Parliament for 5 weeks. Now, what prorogation means is Parliament being shut down. So Parliament has no debates, there's no new laws passed, there's no opportunity to ask questions of the government or to hold the government to account at all. Parliament is completely closed. Now, prorogation is a regular occurrence. It normally happens once every year or so, but when it does, it's normally only for a few days. Whereas here, Boris Johnson was trying to close down Parliament for a whole period of 5 weeks, from the 9th of September up to the 14th of October. And it was widely believed that the reason why he was doing this was to prevent Parliament from being able to stop a no-deal Brexit. So a lot of people who wanted to prevent no-deal Brexit were very angry about this idea of Parliament being shut down. So
we have these MPs, these members of the public, who are very angry at this fact that they seem to have been deprived their opportunity to prevent a no-deal Brexit. What did they do next?
Well, this is where we get to the court action. So there was a group of MPs and members of the House of Lords took a case in the Scottish courts. And Gina Miller, who's a prominent anti-Brexit campaigner, took a case in the English court. And they both took a case claiming that this prorogation of Parliament, this shutting down of Parliament, was unlawful. Now, in the initial hearings, the Scottish court decided in favour of this application, said that prorogation was unlawful. The English court, on the other hand, decided the other way, decided that it was lawful and accepted the government's argument that this was a political matter that wasn't for the courts to decide. The government appealed against the decision in Scotland that they'd lost. Gina Miller appealed against the English decision that she had lost. And this meant the case then had to be held in the Supreme Court, and both of these, the English and the Scottish case, were held together in the Supreme Court, which is the top court in the UK.
Okay, so the case gets appealed to the Supreme Court. And the first question the Supreme Court has to deal with in the case is the question of justiciability. Can you tell us what that means?
Well, justiciability it's quite a long word, sounds complicated, but it's a simple idea, which is the question of whether it is for a question for the courts to decide or whether it's a political matter for politicians to decide. So a matter is justiciable if the courts will be prepared to make a ruling on it. If it's non-justiciable, that means that the courts will not make a ruling and leave it for political matters.
So there was a question then about whether it was, or whether the decision to prorogue Parliament was justiciable in this case. In other words, whether it was for the courts to decide it. And what did the court think about that? Did they think that this case was justiciable?
So the court ruled that yes, this case was justiciable. Now, the Prime Minister had argued that the power to prorogue Parliament was one for him to use on the basis of political considerations rather than legal ones. Now, the court agreed with this to an extent. They agreed that the Prime Minister has the power to prorogue Parliament, and they agreed that he's allowed to consider political considerations when deciding whether or not to do that. He can prorogue Parliament for political reasons. However, the court added that this power has got limits, and the limits of the power to prorogue are to be determined by the courts.
Okay, so the case is justiciable then, so the court is allowed to consider whether the Prime Minister respected the legal limits on his power to prorogue Parliament. What did the court have to say about those legal limits? In other words, what are the legal limits on the Prime Minister's power to prorogue Parliament?
So the court decided that the limits of the power to prorogue are provided by the constitutional function of Parliament. And the court pointed to basically the two main functions of Parliament in the UK Constitution. Firstly, that of passing new laws, which we can call the legislative function, Parliament as a legislature, as a lawmaker. And secondly, the role of overseeing the government, the supervisory function of Parliament, we can call it. And the court decided that prorogation would be unlawful if it frustrated either of these functions without good reason. So if it stopped Parliament from either passing new laws or overseeing the government without there being some particularly good reason for doing so.
So prorogation mustn't unreasonably interfere with Parliament's ability to carry out its main jobs. How did the court apply that rule to this particular case?
The court decided that prorogation for the extended 5-week period would have the effect of frustrating Parliament's supervisory function at a crucial point in the UK's constitutional history. Remember, the UK leaving the European Union is the biggest constitutional upheaval that the country's seen in decades. And Parliament, the court decided, must have the right to have a say in how that process is carried out. So, what kind of Brexit takes place. The Prime Minister had failed to give any real reason for why he needed a 5-week prorogation, why the prorogation period had to be so long. And the court therefore decided that there was no explanation for why Parliament's ability to oversee the Brexit process should be impeded for that period. And therefore the court concluded that the decision to prorogue was unlawful. In their words, unlawful, null, and of no effect. It's worth adding here that the court did not say something that has been reported in much of the media, that the Prime Minister had lied to the Queen. We don't know what Boris Johnson said to the Queen in that meeting, and that wasn't a matter that was discussed by the court.
Okay, so that's a really good summary of what the case was about and what it decided. My next question is, why is it such an important case?
Well, it's an important case for a number of reasons. One, perhaps the most obvious one, is the immediate political significance of the case. It meant that the government had to change its approach towards Brexit in order to accommodate the fact that Parliament was going to then be sitting for those 5 weeks when they had planned it to be shut down. But there's more general importance to this case as well, in that it gives a nice illustration of the roles of the different branches of government have to play in the UK Constitution. So by the different branches of government, I'm referring to government proper, as it were, which is what we call the executive, Parliament, and the courts. So the government has got certain legal powers to make decisions about the day-to-day running of the country. And this includes the power to prorogue Parliament, as we see in this case. Parliament's role then, as the court emphasised, is one, to pass new laws, and two, to oversee the work of government and to hold the government to account. And then thirdly, we have the courts. And the courts have got the task of determining where those legal limits to the government's powers lie. So although it's the government which is charged with running the country, they are monitored both by the courts and by Parliament. Parliament will oversee them from a political perspective, and the court will oversee the government to ensure they stay within the bounds of the law.
And this case also demonstrates how the drawing of these boundaries between the different branches of government can be a controversial business, doesn't it?
Absolutely, yeah. And so a number of people have been very unhappy with this court decision. I mean, for example, many people would say that disputes between Parliament and government are really political matters, and that this debate about whether or not we should have a hard Brexit, to what extent the government should be allowed to threaten hard Brexit with the European Union and potentially force through a hard Brexit or no deal Brexit. This is a political matter. It's not a legal matter. And therefore, this is something that should be determined in the political arena, in Parliament, rather than in the courts.
One problem with that line of argument is that this particular dispute couldn't have been solved in the political arena. Parliament can't effectively scrutinise a prorogation decision for two main reasons. The first is that it has no say over that decision prior to it being made. It's a decision which the government makes by itself. The Queen actually makes the formal decision. Parliament has no power to prevent that decision from being made before it is actually made. The second reason is that the decision has the effect of preventing Parliament from scrutinising anything once it has been made. As you said before, prorogation shuts down Parliament, so there's absolutely no possibility of Parliament scrutinising the decision while it's in effect. So the only real possibility for scrutiny comes after this 5-week prorogation has finished. And as the court said, that would at best allow Parliament to close the stable door after the horse had bolted. So the Supreme Court pointed out quite rightly, in my view, that if the only available scrutiny is by Parliament, then there's no real or effective scrutiny at all. And the court also disputes that this question is essentially political rather than legal. It emphasises that even when a decision is extraordinarily politically controversial, it must still comply, or the decision-making process must still comply with certain legal limits. The court accepts that it's not for them to question the policy, it's not for them to question the politics behind the decision, but it is absolutely right for the court to make sure that the law has been followed, which is exactly what they do in this case.
But isn't there a problem with democracy here? I mean, isn't it undemocratic for the courts to be overruling the decisions of the government? I mean, after all, the courts are not elected, the government is elected. Is that not a concern?
I take the point, but I think there are two important things to bear in mind. The first is it's important to note that we have a parliamentary democracy. We elect MPs, not a prime minister or a government. When we vote for the MP to represent our constituency, not for the person we want to be the prime minister. And so the government has no direct democratic mandate. Whatever power it has, it gets from the fact that MPs support it, that MPs typically vote in favour of the government's decisions. And so the government has no authority without the support of MPs. And of course, the apparent reason for prorogation was that the government had lost that support, but wanted to carry on governing regardless. So it's not at all clear that the government was acting democratically here. And in fact, it was seeking, through its decision to prorogue Parliament, to curb the power of our most democratic institution, the one which is directly elected, which is Parliament. And the second thing to bear in mind is that democracy isn't just about whoever wins an election getting their own way. Democracy also means complying with the law and complying with principles of good government. The court therefore decided in this case that the government must respect the limits of the Constitution, including the core rule of law idea that the government must obey the limits of the law. The government doesn't have a power to do whatever it wants. It has to do only things which are allowed by the law of the land. And it's the court's job to uphold the law against government, and in a democracy it's entirely proper for a court to do so. So on this view, the court's actually protecting democracy in this case. It's protecting the rights of Parliament as the main democratic institution, and it's protecting those core principles of our democratic constitution.
Well, we've spoken a lot about the clash between the different political institutions, between government and Parliament, between government and the courts. I'm wondering, are we missing somebody out here? Right? What about the people themselves? You know, it's supposed to be in a democracy that the governing power is supposed to come from the people, right? You govern with the consent, with the authority of the people. Now, the fact that this decision to leave the European Union, this wasn't just a political decision made by government, this was a decision made by a referendum. And we haven't really spoken about that very much. And I think the court kind of ignored that fact, didn't they? I mean, the court didn't really take into consideration in their reasoning the fact that Brexit wasn't just an ordinary governmental decision, but was a decision taken by referendum. So shouldn't this have some further weight? I mean, shouldn't the court have taken this into account, the fact that this is a decision made by referendum?
Well, first of all, I think it's important to point out that the court didn't ignore the referendum altogether. The court, early on in its judgment, recognises that a referendum had taken place, and it recognised that the decision of that referendum to leave the EU had a real political significance. It had been taken as politically binding. What the court does say is that the referendum doesn't have any overriding influence over the specific legal question of whether this prorogation was lawful. And there are a few things to bear in mind here. First, it's really important to note that the referendum itself didn't decide what kind of Brexit we were going to have. Whether we left with a deal or without a deal, or what kind of deal we left with, this was something that still had to be resolved. Whether through ordinary politics, through Parliament, or possibly through another referendum. The government decided it didn't want another referendum to decide the kind of Brexit that we wanted. So it was entirely correct that Parliament should have a say in deciding the kind of Brexit we ought to pursue. And remember, as you said before, at the time of the prorogation decision, which was challenged in the military case, Parliament was mainly concerned with stopping a no-deal Brexit, where the UK leaves without any kind of deal whatsoever. and prorogation was designed to thwart Parliament's ability to stop a no deal. And just as a referendum doesn't decide the kind of Brexit we should have, it also didn't decide that Brexit should trump the ordinary principles of the UK Constitution. And it's not clear to me why anyone would think that the ordinary rules of the Constitution should be dispensed with just because a majority voted for something in a referendum. I suppose it could be argued that the majority have spoken and that their will should override everything else. But that ignores the fact I just mentioned, which is that democracy, at least in the UK, doesn't just mean the majority getting whatever it wants. Democracy also requires that political institutions serve the people in a more general sense. And a key part of that duty to serve the people is the requirement that there is proper legal and political accountability, which means it's entirely proper that Parliament and the courts have a role in overseeing the government's attempts to put into practice the decision of the referendum.
Yeah, well, I think that I think perhaps this is a debate that's going to go on and on. But I do think that the discussion we've had has done well in terms of pulling out various points of importance that come out of this decision. I think it's important to bear in mind, as you note, that this isn't simply a matter of undemocratic courts against democratic government, because it's also government against Parliament, with Parliament having been the one that's directly elected. It's important, as you mentioned, that the government needs to obey the law, and that we need an independent court in order to uphold that. And none of that is to say, obviously, that the democratic will of the people is in any way unimportant as well. I guess where to strike the balance between those things is always going to be controversial. But yeah, it's been interesting discussing these issues with you, Tom.
Absolutely, likewise. Thanks, Alex.
Thank you very much, and I hope everybody's enjoyed listening to our little discussion. Goodbye.
Goodbye.